basis that, let's say today you're going to the children's court with an adoption matter. I'm just picking a random example, and that you want to just have the principles of an adoption. Where do you start? What are the relevant section? What is the principles? What should you know? What is an adoptive child? What is an adoptive parent? Where does consent? How do you do away with consent? The idea is that I wrote the chapter to such an extent that you can download the document, or you can print the document, and you can take that to court with you. So it's an easy reference to adoptions that can help you through the process in preparing for the adoption case. What do you have to look out for? What questions do you need to ask, depending on which party in the adoption? Are you representing the adoptive parent or prospective adoptive parent rather? Are you representing the mother or the father that want to give up their child for adoption? Or are you representing the child? Keep in mind that the child of 10 and older can consent to or must consent to an adoption. So that is various parties. So the idea really was that you take that chapter that is applicable to your case on that day, you use it as an easy reference, and you take it to court with you. Similarly, where some of you made reference to the Hague Convention, similarly, if you are dealing with the Hague Convention matters, the course material was written in such a way that as a brief glance, you have a summary of what it is, you know where to find it in the Children's Act, but then also breaks it down for you in terms of principles, in terms of how you must look at it, how you must approach it. Some of the relevant case law, especially in the Hague Convention, nowadays it's very much based on what the courts find and how they rule on some of the defenses. So especially the Hague Convention, you will find a lot of the principles is in the case law and how the courts apply that. The Hague Convention, I see a few years ago, just as an overview, we're not going to talk about that chapter tonight, but as an overview, in the past, children were returned more than they were allowed to stay. I see that trend a bit is moving in the other direction. The high courts are more leaning towards letting the children stay in the country than sending them back to the country of origin. But when we come to those chapters, we will have a better look at those at that chapters. So any questions up to now? You can raise your hand, you can just shout out, you can type it in the chat box. It's all up to you. Okay. What I want us to do before we look at the course material specifically is I want to talk about a bit about, let's call it housekeeping. Because last year I found there was a bit of confusion about some of the activities and how we approach it and how it is applied. So you'll see in your calendar, today is Wednesday. So quite by accident, Wednesdays are always it's called an online forum, but it's not. So on every Wednesday from 6 to 7, I will be online to see which question you post through the week. But it is not like a WhatsApp conversation, if I can put it like that. So let's say for instance, Monday night, you were looking at some material and you had a question, you will post the question. But Wednesday night from 6 to 7, I will go online and then I will answer your question, which you might have posted already on Monday. So that that's why I say last year I saw there was a perception that if you post the question on Monday, it's going to be answered immediately. But that question will only be answered on Wednesday for that hour that I am online. If you then post a question while I am online on a Wednesday, then for sure it will be a bit of an interactive session. But otherwise, I will address your questions which you have posted through the week on Wednesdays. So that is the one thing so every Wednesday night between 6 and 7, I will be online to deal with your questions, except not tonight, because tonight the webinar and that online forum is sort of, you know, the webinars replacing that. But that is for the weekly online session. I just see there's a question. Tertia, how do we go about downloading the material? There is a way. If the technical problems, I don't see Grace. Usually Grace is the lady from Lead. I know she's very good in answering her emails. If you have any technical issues downloading or with the website, please contact her. But as far as I remember, there is a way that you can download the material if you're on the specific section of or chapter. You can download it. If you can't get it right, just drop a quick email to Grace and she will assist you. Okay, let's see. There was another question. Okay, Tasha, that's a pleasure. Okay, so that's the one thing that I wanted just to highlight because so there was some confusion last year. Then the other, sorry, there's somebody to join. Let me let them. Okay, so that's everyone now. Then with regards, and there was a suggestion, and I want to hear what you are saying. What do you feel about that? Is that a lot of times I will post the topics for, maybe just let me go back to one step so it makes more sense. So your portfolio consists of more than one question. And the idea is that the portfolio one will be due on a certain date, but then leading up to that date, I will release the three, let's say the subsections of your portfolio, I will release on a weekly basis. So by the time
turn it down.
Marky? Where's Mark? That one. Vicky?
Yeah.
Marky, you gonna...
You can go there. What's happened?
Can I please ask that everybody just mute themselves? Somebody is not muted. Okay. So what happened was that I would then, as I say, on a weekly basis, I will release the first question of the first portfolio.
You don't mind if this is on?
No, it's fine. You muted, Mark.
Yeah, I am.
Mary Ann, can I please ask that you mute yourself? Thank you. So what happened was that I would release the first topic of the first portfolio, and then for some reason or another, there was a technical issue, and then the site didn't send all of you a SMS or an email to say the first topic has been published. And then there was a bit of a panic because you want to get the first topic done so that your first portfolio is on time. So one of the suggestions from last year's group was that we might have a little WhatsApp group amongst all of us that are, you know, me and you, that we then on the WhatsApp group can say to you, okay, guys, I've published the first topic on the website. You can go and have a look. So that bit of communication, I think also with load shedding, which is also unfortunate reality. I don't know if everybody gets an email or an SMS because of the load shedding and the connectivity issues that goes with it. So I don't know in terms of if you think that will be a better way, maybe just to make sure everybody is on the same page in terms of topics. And look, the WhatsApp is not necessarily going to be to ask for advice or but if you maybe get stuck somewhere, we can use the WhatsApp group for that also. So I don't know what is the opinion. What do you think that will work? Let me see what everybody says. Okay, Natasha, that's also a good way of knowing to get some colleagues to know. Yeah. Anybody else? What do you think? You can just put up your hand if you think that's a good idea. Okay. Okay, seems that overall it's a good idea. Everybody is in agreement with that. So what I'm going to do is I'm going to, somewhere in the chat room now, I'm going to put my cell phone number. Come now. Sorry, I'm working from my tablet tonight. And, so please just send me a WhatsApp with your number, and then I will create a little WhatsApp group. Okay, I see Lerato and Janique, you hand your hands up. Do you want to ask a question, or is it just that you're in agreement?
I agree with the WhatsApp.
Okay, good. Thanks, Lerato.
Hi,
Janique, you just-
Elizabeth. Sorry,
Yes, hi.
I can't access the chat on my MacBook, and I can't access it from my phone right now. I can't open the link. Can you just read it out loud, because I have no access to the chat?
Oh, okay, yeah, sure. No worries. It's 083
Yes.
712 4117.
Thank you so much.
It's a pleasure. Okay. Anybody else wants to ask a question up to this stage? Let me just put my phone on silent, otherwise all the WhatsApps coming in is gonna make a noise here in the background. Okay, so the other thing that I know a lot of people usually ask about the assignment is what, am I going to send you to go and do research, or what kind of questions? And you'll see really it is practical questions, because I want to see that for me it's about that I can see that the material that you're reading, that you take it in, but that you can apply it in a practical way. So you'll see the questions I'm going to post for the activities and the portfolio will really be practical. It's almost like one of your cases. You have a client that has this problem, that has that problem. How will you advise the client based on the material that we are currently looking at? So that will be the approach of the assignments that I'm going to give you. And also what I want to ask from you is that if you answer the assignment, please you don't have to repeat everything that's in the material. For me, it's more about that I can see that you've read the material and that you've used the material, applied it to answer the question, rather than just repeating the material back to me. Just apply it. If you want to go a bit wider, I know last year we had a lady here that was she was actually from the Center for Child Law, one of the junior lawyers there, and she really went more into the bigger theory of children's law and children's rights. If that is what you want to do, by all means, there's no, for that, for me, I just want to see that you understand the principles and that you're going to apply it. In the second portfolio, you'll see I do, because we then look back at all the material. One of the questions is usually a bit more wider, in the sense that if it's a bit, let me say, I want to give you a bigger problem and see if you can take the material and apply it to all the theory to a problem for a child. To say this is the child's problem. If you look at all the facts and the theories that I've given you, can you, from all of that, pull something to solve this child's problem? So in the second portfolio, there will be a bigger, let me call it a bigger question that will involve all the chapters. But the first portfolio will deal with the first chapters that we're going to have a look at tonight, so that you can understand exactly what we're talking about. So if tonight we're going to look at the best interest, so that your first portfolio will come from the first 4 chapters, so which will be in their best interest, parental rights, children's court, and children in need of care. So those will be your first 4 chapters. Shanique, I see you still have your hand up. Is there something you want to ask? Oh, okay, was just an old hand. That's fine. So that is so you can, for now, we can be sure that your portfolio 1, your question will come from the first 4 chapters, and your first question for the portfolio will be released by Friday. And then what will happen is on the group, I will just say to you, okay, I've released the first question, you can go and have a look, so that there's no communication problems going forward. I see the WhatsApps are coming in. I will create a group and then I will add everybody to the group. Any other questions? But I also, sorry, my tablet is playing tricks there. Okay, sorry. But I also just wanted to say that what we will do is since the material was published, there's also been some further case law around contempt orders specifically that we will specifically look at one of the webinars, not tonight, but it will most probably at the next webinar. And then also the material is not yet part of the course, it's the rules of the children's court. The rules have already been signed off, it's been done, but it's still being translated. They want to translate the rules into all 11 languages. So although the rules have been finalized, they've been signed off, they have not been published yet because they are still being translated. So what I will also do is during most probably the last webinar, I will spend some time on the rules, because it is important that if you're going to say, well, I'm going to litigate in the children's court, that you also understand the new rules, especially how it relates to the children's courts. You will see it brings in some more forms, unfortunately, but it also clarifies the process of bringing a matter to the children's court, because there's, I saw some of you said, well, I have been practicing in the children's court, and I know going from one jurisdiction to another, some courts will accept a notice of motion, like you will start any civil application, and then other children's courts will say to you, no, if it's not a Form 2, I'm not going to look at it. There must be a Form 2. If you then want to attach a notice of motion to your Form 2, by all means, but a Form 2 is the only way you start a matter in the children's court. So the rules, to some extent, clarifies that process, and you will see also when we look at the rules, the objects and the principles of the rules are very much the idea of simplifying, of expediting, of making it more accessible. That is the principles and the object of the rules. It's also formalizing things like case management in the children's court, or judicial case management, I must rather say, which to some extent, if we look at the children's court and the way that the children's courts are running at the moment, there's already this aspect of case management. I mean, you go back to court and then the magistrate will say, okay, this is outstanding, that is outstanding, this must still happen, that must still happen, maybe make a few interim orders and then postpone the matter for another 90 days or 60 days, depending on what's outstanding. So the rules now just formalizes that a bit and gives the magistrate some more, I don't want to say power, but maybe guidance as to what exactly can be done as part of a judicial case management process. So that's why I think it's important that we just look at the rules, that by the time that eventually they've translated it and it is published, that you already are aware of the rules and you know where to find it and what to do, and you know how to, where, especially in the children's court, if you want to litigate, how do you do applications. For example, now it formalizes the whole principle of urgent applications in the children's court, and we'll also have a look at that and say, okay, how is that done, and how will we approach that? Okay, so any questions up to now? No question. Okay. As I said, the first portfolio will deal with the best interest standard, parental rights responsibilities, the children's court, and children in need of care and protection. And those are the first four chapters of your online course. And I'm not going to go into each and every aspect of that. I just thought to give you some guidance into some principles of each of the chapters that you can have a look at, that you also understand maybe what it is that you'll have to look at to do the first portfolio. So the best interest standard, for me, it's always wonderful that eventually with the new Children's Act, and you'll see, I say that in the introduction, that they eventually gave it a definition in terms of Section 7 to give us a little, and you'll see I also talk about, it's a little checklist. It's a wonderful thing. A lot of times when I write my curator reports, I use those 13 factors of Section 7 as a almost like a little, I call it a checklist. If I take the fact of the matter, I use that checklist to evaluate the facts, to see with regards to that child using Section 7, what is in the best interest. Just want to see there's a question. Hi, Marilee. Yeah, Marilee, if you, I think maybe because there will be a WhatsApp group now, you can maybe just let us know that you won't be able to attend. I know Grace will release the recordings also onto the website. So if you can't attend, then you can just always go into the recording afterwards. I hope that answers your question. Okay, thanks. Okay. So guys, as I say, the very first chapter was the best interest, and I really wanted to make it the first chapter because I think you all know, if you've heard it gazillion times and you've read it, that the best interest standard is ultimately everything, and it's paramount to everything. And it's usually that thing that we use to determine a lot of things. And I'm currently a parenting coordinator in a matter, and then I've the father, and needless to say, the father and the mother, and we communicate via WhatsApp. And he loves to end up his sentence, but he can be very dictatorial. He can be very bad, like, I'm the father and I'm going to give the instructions. And then he would end off his messages by saying, and everything is done in the best interest, and then he would now name the child. And I said to him, just because he says it doesn't make it so. And unfortunately, I think people still have this idea that if I say I'm acting in the best interest, it is, it's almost like a statement of the fact. But if you look at the best interest, then it consists of those 13 principles. And if you want to say something is in the best interest, you must go back to that and say, okay, but what of that 13 factors can I tick off to say this is really in the best interest? But yes, ultimately the best interest is that test that we use overriding to everything, what is in the best interest of the minor child. And if you look at then and what the Act says in terms of the Bill of Rights, Section 7, it says everything. Section 9 again confirms that principle of the best interest standard. But please, it's more than just the words. It's really the substance to that. What we also sometimes forget to look at and under the best interest principle, you'll see that nowadays more and more it is something that not only in the Children's Act, but if you look at any piece of legislation, we sometimes as lawyers and we forget to go and look at the object of the act. What is the principles of the act? Because in that also lies how we use the act. And especially when it comes to things like the Children's Court, and I'm sure if some of you that appear there, and I sometimes really feel like I sit there and I feel like, today it feels like a parent's court. Today it feels like a grandfather or a grandmother's court, because we're going on and on and on about the parent and the parent's rights and the grandmother's rights or supposed rights, but that we lose focus on why we are here. And if you look at the principles of the Act, and it says that all proceedings and actions and decisions of the Act, of anything that is in terms of that Act, must protect, respect, and promote and fulfill the child's rights. Not the parents' rights, not the grandparents, not the family, not the auntie, the uncle. It must be about the child. We must there to protect, respect, and promote the child's rights. Make sure the child gets the right assistance to develop, is treated with dignity. And so, and if in any children's court inquiry, be it an inquiry in the children's court, but even if we're just busy with a divorce and we look at the parental rights responsibilities, the way that we apply that, are we concentrating on the respect and the dignity of the child, or are we going on and on about the rights and respect and the dignity of the parent? For me, sometimes we all scream, and that's why I say we all say the best interest, and we're doing this in the best interest. But part of that best interest is looking at the child and the child's rights. So it's important that if we look at chapter 1, the first best interest, that we also we go back to the principles of the Act that takes us to the Bill of Rights, that takes us to the Constitution, that talks about the child's dignity and the child's respect. You also see in the summary of in the course material, I refer you to some case law, which you can go and see exactly what the courts have said around the best interest. Just one, and I see I haven't changed it, and my apologies for that, is that section, the one referral in the course material to Solar versus R, it should be Solar versus G, sorry, and that I must still speak to Grace that we changed the reference there. The year is right, it's a 2003-5 judgment of Judge Solar. Judge Solar, sorry, I'm looking at Solar and then I'm saying the wrong name. Judge Satchwell is already retired, and it's quite an old judgment. But if you look at the judgment, and if you look at the difference between legal representation, you look at the family advocate, something nowadays that are the new phrase that everyone wants to use, parental alienation. Even in 2003, if you look at that judgment of Judge Satchwell, she's already had something to say about alienation, about children, about child participation. And what's nice about that judgment is that she said that if as a legal representative for a child, you stand squarely in the corner of the child. And for me, it's been always such a nice illustration, and I can see it in my mind's eyes, this idea of a boxing ring, and you are there, and you that coach or the water man or the water girl for the boxer, and you are standing there and in that boxer's corner. And when that boxer gets there after a fight and you give them water and you give them a towel and you stand there and you cheer and you fight. So for me, it's such a beautiful illustration of exactly what it is that what does it mean to represent a minor child. You'll see also at the end of the chapter and the introduction to the chapter, there is a self-assessment on activity. This is not the activity or the self-assessment that will form part of your portfolio. This is purely to test yourself. Once you've worked through the course material for chapter 1, test yourself to see if you understand what the principles are that we were talking in chapter 1. Any questions on that, comments? Please also, if you want to share something, please do that. Okay, so I see no questions, no remarks. So the another chapter that you will have to look at for your portfolio 1 will be parental rights and responsibilities. Now, somebody just, when we started, were talking about divorces, family law, parental rights responsibilities. What do you do with that in terms of a divorce? And it is important to remember that initially when this act was written, I think like all legislation, when it is written by the Law Reform Commission or researched by the Law Reform Commission, the idea with parental rights responsibilities and the exercising thereof, there was always the idea or the wish maybe that parents or people exercising parental rights responsibilities will have a parenting plan, will have a parental rights responsibility agreement, and that plan or agreement will be mediated. So, and I think that's where a lot of the confusion comes in that sometimes people still think about parental responsibilities and rights as a residency issue or access, let's use the old terms, access and custody. But if you look at the definition of parental rights responsibilities, the definition consists of 4 elements, being care, contact, maintenance, guardianship. So if you are a holder of parental rights responsibilities, you are the holder of all those things: care, contact, maintenance, guardianship. And if you are married, or if unmarried but rights are recognized, both parents are the holders of full rights. So they're on equal footing. Each has 100% parental rights and responsibilities. It is how it is exercised that is important. And that's why I said when we started that when they initially wrote the act, there was the sorry, there was the understanding that parents will sit and they will mediate or they will discuss on how are we going to exercise it. So that is why through the years, this idea of residency has come forward. Because if you and I are the 100% holders of parental rights and responsibilities, we must say how it's going to be exercised. And one of the things we need to decide is where's the child going to stay? So that's how the idea of residency came about. But if you look at the definition of care, for example, it talks about not only the day-to-day care, but it talks about guiding the child in terms of education, in terms of giving the child, making sure there's medical treatment, there's education, there's, yes, guiding the child emotionally. So care, if you look at the act, the definition of care is very, very, very wide. And it doesn't, actually nothing to do with residency, because residency is what? Residency says the child must stay somewhere. But even if the child is staying with a father, the mother and the father both have parental rights and responsibilities, which include the care, which says that even if the child is staying with the father, the mother still has a care responsibility, and it is a responsibility, because the mother must still care for the child in terms of guiding the child emotionally, guiding the child educationally. But and practically, the child must stay somewhere. So there we come with residency. So they must agree on residency, and somebody must pay maintenance. But the responsibility of maintenance falls to the shoulders of both holders of parental rights responsibilities. The same with guardianship. In terms of a mother and a father, let's talk about a mother and father. They are both holders of parental rights responsibilities, which include guardianship. It becomes, this idea of parental rights responsibility becomes a question when we are dealing with unmarried fathers, and we then have to look at Section 21. Because as Section 21 reads now, it is an all. So you lived with a mother at the time of the birth in a permanent life or relationship, or you tried to pay maintenance, you tried to take responsibility, or you pay damages in terms of the customary law. Now, they've been trying for, I think it was before COVID, so let's say it's 2 years now. They've been trying to push through Parliament an amendment to the Children's Act. As part of that amendment would be the idea of an automatic right to unmarried fathers, to do away with this almost a test. Do you fall in that category? Do you fall in that category? Do you fall in that category? And if we can say yes, 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 then you have rights. But that can still be sometimes be in dispute. So in the amendment that's still not being pushed, that hasn't been published and they haven't been finalized, this idea of an automatic acquirement of parental rights responsibilities for unmarried fathers. But let's not confuse the issue between married and unmarried fathers. You'll see the Act still differentiate between married fathers and unmarried fathers, because that's reality. But mothers, because they are the mother of the child, of the holder of full parental rights responsibilities. The other question I know a lot of people have, and you will have a look at the Act, it's very clear that only if she's the sole holder of parental rights responsibilities, so she's not sharing those rights and responsibilities with anyone, can she give it to a third party? Or she can appoint a guardian for the child if she passes away. But if she's not the sole holder of parental rights responsibilities, she cannot just decide to give it to somebody else. She needs then the permission of the co-holder of parental rights and responsibilities. And parental rights responsibilities plays a role, or this concept in, not only divorces, but in any care and contact dispute. We need to go back to that question, okay? Who's the holder of parental rights responsibilities? Was it suspended? Was it terminated? If no, then who are the holders? Can that person share it? Can they not share it? Can they appoint a guardian? And also, what is guardianship? And it's important. There's also a lot of problems that come in terms of guardianship. Somebody mentioned about High Court and what can a High Court do in guardianship. As it currently stands, you'll see specifically in this chapter, it says specifically that, and also with the Children's Court chapter, that only the High Court at this stage can deal with guardianship. Again, in the amendment that they are trying to push through Parliament, there's a suggestion that the assignment of guardianship in terms of orphaned and abandoned children, that power should be given to the Children's Court. So that all these children that are clearly orphaned, that their mother and father have passed away, or they are abandoned by a parent, at least the caregiver of that child can go to the Children's Court and can get guardianship and don't have to go through the long route of a high court and also the expenses of a high court. Sorry, I just want to see if there's somebody that wants to be admitted. And I don't know who of you have done guardianship matters, but in any way, as we are, I litigate in both the Joburg and the Joburg and Pretoria High Court, and they still insist on social workers' reports. So in any way, the High Court wants a report from the social worker. And also some of the organizations, I'm finding it more difficult than ever to get some of the social work like DSD, any of the other organizations to get a report, to give a report that the High Court will accept. So just imagine if we can put that process through the Children's Court, who can, as part of that process, in any way, instruct a social worker to do a report. We don't, and it's easier to get into the Children's Court. It's quicker to get that one order, just a form that's actually issued to say, you social worker, please do me a report. I know a colleague of mine that actually, Rian, you practicing in PE, also I didn't know that my colleague is in Pietermaritzburg. He, it's become so ridiculous that he now first goes to court and get the court to give an order for the family advocate to do an investigation. Because as you know, the family advocate, if you just serve a form 2 on them to say, or form Annex B, do an investigation in a guardianship matter, they say no, because they're not tasked with guardianship matters. So he needs to go to the court first, get an order to instruct the family advocate to do an investigation, which is so unnecessary and time consuming. And in the meantime, you're sitting with a child that has no guardian, and while the child has no guardian, they cannot access certain services. And we are talking here about months and weeks ago past that we could have actually solved this child's problem if we can take the matter of the guardianship through the Children's Court. It seems from my understanding from the ladies of the Law Reform Commission is that there's a bit of politics behind this, that there was this idea that maybe, if we take away this jurisdiction from the High Court, they, as upper guardian of all children, they might feel that they are being undermined in dealing with children's matters. But I think, unfortunately, that is just not true. They will always be the upper guardian. You can take anything to the High Court. Even if the Children's Court has jurisdiction in guardianship matters, you can still approach the High Court. So for me, that little bit of possessiveness of the High Court does not make sense. And I just, in my opinion, children are just suffering and not accessing services because the caregivers cannot approach the court to get the necessary order. And you know yourself, there's so many people out there that think that are sent from pillar to post. Oh, just go and get a guardianship letter. As if somewhere you walk into an office and somebody gives you a guardianship letter and they stamp it and go like, oh, congratulations, here's a guardianship letter. And as soon as they find out that the whole process, it is that they lose, not interest, but I mean, they cannot just get to it. They cannot afford to do it. So I see, sorry, there is somebody admitted, Annette. Okay, so that deals with then briefly parental rights responsibilities. And I specifically in the summary to the chapter, I say, please look at the section 1 definitions, because it's very important that you look at the definition of care, contact, what is a parent and what is the caregiver in terms of how you practically apply parental rights and responsibilities. And also, parental rights and responsibilities can be terminated. It can be suspended. It is something that is happening more and more, especially in terms of the children that I'm acting for. The other day, a child told me that she wants to divorce her father. So yes, we can't divorce them, but I can ask that his rights be suspended or can terminated. Because if she says, well, she doesn't want him to have rights anymore, then that is something that we can consider, is to bring an application to terminate his parental rights responsibilities. Also, in terms of parental rights and responsibilities, you will find this is sections where you have your grandmothers, your grandfathers, that will apply to the children's court and say, give me rights. I want to share the parental rights responsibilities. It's usually not the residency part of it, it is the contact part of it. So they will say, but because of what, historic, somebody died, my child, I still don't have access to my grandchild. Please give me the right of access. Unfortunately, if you go and look at the case law, it is very clear that if a grandparent applies for rights, and let's say the contract rights, the one test that the court will look at is to see if that right and giving the right will lead to conflict. And if there's going to be conflict between the grandparent and the holder of the parental rights, so let's say the mother, it's usually the mother, but let's say it's the father, but a parent, the courts has consistently said no. The grandparent cannot have rights if that exercising of that right is going to lead to conflict. The child has a parent, and they come now and say, give me some right, give me contact. But if that parent, the grandparent, cannot in peace coexist with the parent to exercise the rights, the courts have now consistently said no. I'm not going to give you rights as a grandparent. So again, in terms of this chapter, section 23, the grandparent will have to convince a court that their right or having part of the parental rights responsibilities is in the best interest, in that they have the right attitude that will not lead to conflict. Because if you look at a lot of these cases, unfortunately, it is because their own child has died, or they might have been a divorce. And humanly, they a grandparent, they have their own child, and they choose sides. And they then say, well, but I want contact with that child. But actually, the parent who is now looking after this child, I don't like that parent. And they usually don't have no problems in voicing that dislike. And a lot of times that voicing comes in front of the children, or the children are quite aware of this dislike. And then the court says, but why must we expose this child to this? Because now the child's going to go to a person, and the message that child's going to get from that person is, oh, I know your mother is this or your mother is that, or, she left your father and your poor father. And so unfortunately, that is a lot of times is that's the situation around the grandparent. But again, look at this, it's section 23 in terms of the exercising of parental rights and responsibility. So if we then move on to a more the children's court, which is a longish chapter in terms of how, and it's important when you look at this chapter, there's a few things, and the one most controversial thing we'll have a chat in about now is what is it, which court is a children's court? When can the court be approached? By whom it can be approached? What kind of orders can the court make, and how does the proceedings look? So if you want quick answers to all of this, you can actually look at section 45 and 46 of the Children's Act. So 46 of this chapter deals specifically with what kind of orders can the court make, which is very important, because I think all of you know that the Children's Court, because it's a magistrate court, is a creature of statute. So the orders they can make is in section 46, linked to your other sections of 150 that deals with children in need of care. But ultimately, you need, if you want an order from the Children's Court, you need to be able to fit that order into one of the subsections in section 46. And I recently, for some reason or another, in the Children's Court is sitting with children that has moved from one parent to another parent, and it's both of the cases is from their mothers to their fathers. And in the move, the mother is refusing to give them their dog. So the one dog's name is Frikkie, and Frikkie is supposed to go to Cape Town, and the other two dogs are Chichi and Rosie, and they are supposed to move to Randburg. So as typically as these things go, the children were removed from the custody or the care of the mother because of issues at the mother's house. And then because the mother is now feeling angry and upset about the child or children being removed, there's now reluctance to send the pet of the child with the child to the other home, which, if you think about it and you look at it objectively, it's just absolutely silly and ridiculous that you punish your child through a pet because your feelings are hurt. But be that as it may, and the children specifically, when I consulted with them, say to me, okay, but please can I have Frikkie or Chichi or Rosie? So if you go to section 46 of the Children's Act, there's no place there for delivering of a pet, because the Children's Court cannot make such orders. But if you look at section 46, the Children's Court can make orders that can provide emotional support or emotional well-being for the child. So in both of these cases, I could convince the court that Frikkie, the one dog that's going to Cape Town, is an emotional support for the child. There's an emotional, the child feels good with it if the dog is with him. And then the other one, Rosie, also the therapist of the girl, actually specifically asked us to see if we can't get Rosie to come and live with this specific teenage girl. She's already depressed, she's suicidal, and in the therapist's opinion, really, Rosie the dog will be support to the girl. But the only way you will ever be able to try to fit in an order is if you look at section 46 and you go and see in terms of what specific subsection you'll be able to fit in an order. That is very important. And then section 45 of the Act, that is also important, that says what type of matters the Children's Court can deal with. Then the one thing, if you look at the Children's Court and then subsection 1(4) of the Children's Act, it specifically says that the Children's Court cannot deal with matters arising out of a divorce or the Divorce Act. So there was a lot of debate about what is arising out of. So some people would have interpreted to say that if a high court made a divorce court and you want to vary the divorce order, you cannot go to the Children's Court because that is out of a matter, it arises out of a matter flowing from the Divorce Act. you will see there is a link in your course material to the judgment of the Afrikaner matter. It is a judgment, actually it's a review matter. The magistrate herself sent two matters to the High Court for review. Because she kept on getting these arguments in the Children's Court about the Children's Court cannot do this and that and the following. And she said, please, for myself, for clarity, I'm referring this matter to the High Court. Please, High Court, give me guidance on what matters I can do and not do. If you read the judgment, you will see the High Court eventually said that if a divorce matter is done and dusted over, be it that the order was made by the High Court, the divorce court, it's over. You can approach the Children's Court to vary that order with regards, naturally, children. I'm not talking about other things. As long as you can show the changed circumstances. So there the court linked it a little bit to the Maintenance Act, because there, in terms of the Maintenance Act and the Maintenance Court, even if you were divorced in the High Court and the High Court made an order for 1,000 Rand per month, everybody, there's no doubt, there's absolutely no doubt that you can approach the Maintenance Court for a variation of that order, for an increase, for a decrease. Nobody is doubting that. So the High Court in that matter said, but similar to that, if the divorce is over, you can approach the Children's Court to vary the order. And also the court made its interesting remark to say that, but why would, if there was no divorce, and so the child is a child of a unwed couple, can you approach the Children's Court, which is much more expeditious and cheaper than the High Court? So why differentiate between the two types of children? Are you not discriminating now against the children based on, are they born from a marriage, are they born from a relationship? And the court says that could never, ever have been the interpretation or the intent of the legislator when they put the legislation in place. So that was the one aspect. I see there's a question, Natasha. Yes, it is part of it's part of the summary now, Natasha. So if you see every course, every chapter in the course has, it starts with a Children's Court, and then there will be sections, outcome, introduction, course material, activity, assessment, and a summary. So in case of, in this instance, the chapter in Children's Court, right as part of the summary, you'll find the link to the judgment. Okay. Then the other question the court had to answer was, what about if, and I'm sure all of you have found that you are busy with a divorce and then all of a sudden somebody runs to the Children's Court. And now they try to litigate in the Children's Court while there's a pending divorce. And the feeling has always been that that cannot be so, because that's even in terms of a general principle law, legal principle, that you cannot, while a matter is pending in the one court, run to another court and start a new case there. That is not allowed. But the court said that because the Children's Court has jurisdiction over children in need of care and protection, if pending a divorce, that child or children becomes children in need of care and protection, that only that question can be taken to the Children's Court, even though there's a pending divorce, because the Children's Court will have the jurisdiction to deal with children in need of care and protection. And the Children's Court are uniquely equipped to deal with children in need of care and protection. But once that question has been dealt with, the matter must still be finalized in the divorce court. So it's not as if the children's court is taking over the divorce. No, they're only dealing with that one little question in that is the children or child in need of care that is part of the divorce? And I think for me, I've really, in these high conflict divorces, I recently had, or I'm still involved in the matter, where an 11-year-old boy is refusing to cooperate in terms of going to appointments. He's just his behavior is uncontrollable. And if you look at the definition of a child in need of care, one of the definitions are a child whose behavior cannot be controlled. So my question, I really wanted to at some stage start an application in the children's court to look at the child if this child is not in need of care and protection. What stopped me was that this child has been subjected to so many assessments and so many people. And I realized that if I refer the matter to the children's court for an investigation, the child is going to be subject to a social worker, maybe one or two other experts to determine if he's a child in need of care. And that is also not in his best interest. If you look at section 7.1n, it specifically says we must limit the administrative or legal processes that a child is subjected to. But to come back to the Afrikaner judgment, the court says yes, if a child is in need of care and protection, that is something the children's court can have a look at, even though there is a pending divorce. So have a look at that. And I think a lot of you might have already had to deal that and get to that. And the children's court that says, no, but I can't do this and I can't do that. So please, Marika, I see your hand.
Good evening, advocates. I actually just have a question. So we have a matter where our clients approach the children's court first with regards to their minor child, and then subsequent to that application being launched and appearing in court and being postponed, the other party, the other parent, launched the divorce proceeding. So the divorce is now pending after the children's court. And of course, as part of the divorce, contact is also in dispute in the High Court now as well. Does that raise the same issue as if it was the other way around, or can we just carry on then as normal?
Yeah, for me, we've dealt with few matters like that, and our argument is usually to say that the children's court matter was first.
Yes.
And if there's nothing stopping the children's court from finalizing their process, whatever, and anyway, whatever order is made in the children's court can just be incorporated into the divorce, yes. Yeah. But if it was the other way around, you will have in the section 1.4 that kicks in that says, whatever you're now trying to do is arising from a matter from the Divorce Act. But if there was no divorce, that cannot be raised, no.
Okay. Thank you so much, Advocate.
Okay. Okay. So I see you are all getting hungry and it's getting late. So let's finish up. So the last chapter that will be forming part of your first portfolio will be the children in need of protection, care and protection. There it is important that first of all you need to understand when is a child in need of care and protection. Now section 150 of the Act has a nice summary of exactly what that is, or when that is, sorry. But a lot of it is sometimes, like all things in any act, there's a list, a child being subjected to maltreatment, abuse, neglect. But then there's also the elements of the emotional neglect and abuse that can sometimes be a bit vague. But again, look at the facts of your case and go to section 150 and say, well, is there something that makes the child in need of care? Or is this just a dispute as to how parental rights responsibilities are exercised? Now, look, a lot of times, because of the high conflict or how the parents deal with their conflict, let me rather put it like that, the child can become a child in need of care, because if a child is subjected to so much conflict, can we not say, well, that child is being emotionally abused or neglected? If we look at the new thing that everybody wants is shouting, parental alienation. If it's really, really parental alienation, even if you go and look at what is parental alienation, it is for sure emotional abuse, emotional neglect. Because if you think about it and you look at the true definition of parental alienation, that child is systematically being alienated from a parent who they had a relationship with. So how much more, you cannot damage a child emotionally more than that. A few years ago, I had a girl, she was 7 years old, and her father and her new mother and the new wife rather alienated her to such an extent that she started calling her own mother Tannie, what if I translate it in English is auntie. And so she was so convinced that her mother was not her mother anymore, and that on a psychological level she was dissociating. So the only way she could deal with this is like just cutting the emotion and that part of her life off. Eventually, she was reunified with her mother and the problem was solved. But that's why I say if it's really parental alienation, yes, that can be something that can make a child in need of care and protection, because that will boil down to emotional abuse of the child. It is also important that if you then say, okay, well, prima facie, this child seems to be a child in need of care, that you then look at the process that the Children's Act prescribes what needs to be done. The other day I consulted with an attorney and a grandmother and a father, and the children were not in school. So now instead of bringing an application to the Children's Court and say, hey, Children's Court, these children are not going to school. They are suffering in terms of education. Step in here. You must call that mother to task and say, why are you not taking your children to school? They went the route of the High Court, appointing curators and all kinds of things. But that's still not getting the children in school. So my question to them was, but why don't you do the most direct thing to solve this problem? Because if a child is not in school, prima facie, that child is a child in need of care, because the child must be up to the age of 16, must be in school. So my request is, if you look at that, I think we are tempted to not want to use it, because in our minds, we've been taught that removing a child, because that's how we see it. A lot of times, if a child is in need of protection, we remove a child. But if you go and look at the Children's Act, there's mechanisms that the Children's Act says, no, removal is not your first option. It is the only option if the child is being so abused or so neglected that we cannot leave the child in the circumstances. Yes, then the child must be removed. But the Act prescribes intervention services, supervision services. So there's lots of other things that can be done to protect a child before just removing the child. You must also remember the Children's Act makes provision for removing of an offender or the person that is causing the domestic violence. So that's also a possibility. So even us as lawyers, remember, we can also use those sections. It is not only just for social workers. And again, I understand that social workers have, unfortunately, bad reputation. And if you say to somebody, go to a social worker, they go, oh, no, that's like, no, people will think badly of me if I go to a social worker. But if you look at the Children's Act and the mechanisms of the Children's Act, the social worker is an integral part of that mechanism, especially if it comes to children in need of care of protection. You need to involve them. Yes, and I'm also hearing you. Going to some organizations is like hitting your head against the wall. I'm with you 100%. And you feel like, oh, you know, I need assistance, and I understand that. But then go to the court first and say, yeah, I'm court. I'm bringing this matter to you. Give me an order. I'm bringing this set of facts to you. Look, if you look at this set of facts, prima facie, this child is in need of care and protection. And I'm coming to you, the children's court. You are tasked with protecting the children. And I've tried going to that organization, tried to get them to assist me, but they are not. So now I'm asking you to direct them to assist me so that we can protect the child. And I understand. And I think as lawyers and your clients coming to you, you always get to deal with the negative side of this process, because you usually get the client that comes to you that child has already been removed. And everybody is up in arms and everybody just wants to fight. But if you look at the mechanisms of the Act, there's room for going to the social worker, going to the children's court and say, you know what, yes, things maybe it was a bit hectic and hairy and there was a bit of domestic disturbances. But, you know, here I am. The Children's Act says that you as children's court can ask that we are given support services, that we are given supervision services. So, okay, you know what, please give me my child back, and we will agree to go for parental guidance, we will go for this, we will go for that. In terms of, and now I get back to Section 46 and say, well, yes, here we are in terms of a protection process, but court, you, in terms of Section 46, can make certain orders. And now I'm asking, as a parent, things might have gone wrong, but I'm asking, I'm coming. Please help me. And I know, as representing children in these processes, it's easy for me. I look at a different way at these matters. And I understand, I think for you acting for a parent, it's difficult because you have the parent there in front of you, highly emotional, highly irritated, highly upset with social workers. But if you just look at the mechanism of the Act and look at what can be done, sometimes we might find a better solution to this problem than just fighting and being upset and emotional about everything. So that is an overview of the 4 chapters that will be the first portfolio. Any questions, comments? Okay. Well, then we're done for tonight. Then you can now all go and have a nice, hopefully, supper, and even some of you might be in the dark with load shedding. Some of you hopefully have lights already. So please enjoy your evening further, and then I will create the WhatsApp group by tomorrow morning at the latest. I'll add everybody on the group, and then as soon as I've released the topic, I will let you know, and then everybody can go and have a look. Any other questions? No further questions. Okay, then you must have an excellent evening. Okay, bye-bye.